So we're going to jump back into Jarnail Singh's testimony to the Post Office Horizon IT inquiry now, where the discussing the disclosure of unused materials in the case against Seema Misra. And the email exchanges that have previously been identified are actually missing. In fact, no email exchanges are listed at all. Jarnail Singh says he has some time away, but what happened to the case during this time away, and why was these things not picked up on after he described them as being essential to be disclosed to the defence and the court? Let's jump into the inquiry and find out.
Good afternoon, sir. Can you see and hear me?
Yes, thank you.
Thank you. Good afternoon, Mr. Singh. Can we turn to an issue that you raised before lunch, namely what was on the schedule of non-sensitive unused material on the 8th of September 2010. You called it the September 2010 schedule, and who signed it, and just close that issue off, if we may, by looking at poll 305 5217. Can you see this is a schedule of non-sensitive unused material in the case of Seema Misra?
Yes.
And would this be completed, i.e. the typing on it in column 1, 2 and 3 by the disclosure officer?
Yes.
And would the comment column in column 4 be completed by the reviewing lawyer?
Should be, yes.
In legal services?
Yes.
If we look at this schedule, if we just scroll down to the foot, we can see it's dated the 8th of September 2010.
Yes.
i.e. the one that you were referring to, and you asked whether the email exchanges that I was asking you about were on the schedule of unused material, and I said no, they're not. So if we just look at the schedule to start with, we scroll up, please. If you just scroll through all of those items, can probably do this quite quickly, and scroll down.
They don't appear to be there, do they? Even though he previously said it would be essential for them to appear there. So we can see that actually John Longman there has signed this off as the disclosure officer, but who's the reviewing lawyer? That would certainly be interesting, because they've not added any comments by the looks of it at all to any of these things.
And then over the page, and scroll down. You can see that no emails are referred to.
No.
So not just the ones I was speaking about at the time, but no emails concerning liaison with Fujitsu or Gareth Jenkins over the commissioning or contents or parameters of his witness evidence are included, are they?
No.
If we go back to page 1, please.
And considering things that have been included there, like rough notes ahead of meetings and stuff, that's quite a significant omission, really. As Jarnail Singh previously said, it would have been essential for this to end up on the disclosure log.
And whilst we're here, we'll come back to it later, but this schedule of unused material does not contain any drafts of any of his witness statements, does it?
No, it doesn't, no.
Did you know in 2010 that there was an obligation under the law that it had existed under the Code of Practice promulgated under the CPIA 1996 to disclose as unused material drafts of witness statements where they were materially different from the served version?
I can't remember now, to be honest, but I would have assumed I'd been on the courses. I would have been aware, but I can't.
Surely that's not down to being on a course, though. Surely that's down to the fact that actually that's part of a lawyer's job. I mean, I'm not a lawyer, but surely that would be a fundamental piece of knowledge there. Not that you need from a training course, but from just the mere fact of you operating as a lawyer.
I can't recall it.
Assuming that you were aware of that, we're going to see later this afternoon that there were a series of draft statements that passed through your hands, which were very materially different from initial drafts. And in particular, they contained drafting suggestions made by Warwick Tatford.
Yeah, Mr. Tedford, yes.
And none of those were disclosed. How did that come about?
Who signed this? Have I?
Well, you can see at the foot of it, it's signed by Mr. Longman.
No, with the reviewing lawyer. Is it me? Because I know there was a number of people dealing with it.
Well, let's start with how it was supposed to work.
Yeah, please.
The disclosure officer was responsible for collecting together the material
Yes.
and deciding in the first instance whether it required to be listed on this schedule or a sensitive schedule or not at all. Agreed?
Yes, agreed.
They would submit the schedule to the reviewing lawyer.
Yes.
What function did the reviewing lawyer perform in relation to the schedule of non-sensitive material?
Well, he need to, I certainly review every single information he has, or he should have, or if he hasn't, to get the investigation officer to get it over to him, or put it in the schedule for him, and then having reviewed it, finally conclude that it's on here.
And would the reviewing lawyer sign it?
If he's happy with it, he will only sign it if he's happy it's all complete. Yes.
You'll see the way this form is designed, that there isn't an obvious place for the reviewing lawyer to sign. The signature that's underneath that GRO there is Mr. Longman's signature.
Oh, is it? I don't know. I mean, I presume that there's a reviewing lawyer. Maybe we need to. I don't know whether I dealt with it, whether I signed it next to where this reviewing lawyer is.
That's what was supposed to happen, was it? That it was signed next to the words reviewing lawyer to show that the two-person process of the disclosure officer on the one hand and the independent of the disclosure officer, the reviewing lawyer on the other, had each applied their minds to the contents of the schedule.
Yes.
It's not at all obvious, is it, there? And indeed, we can see that there isn't a signature from the reviewing lawyer in any case, so has it been reviewed at all? Maybe, but there's no way to know that from this piece of documentation.
And so would you get copies of these documents here, 1 to 11,
Yes,
when
yes.
you got this schedule?
Oh, absolutely, yes.
Right.
You should be enclosed with it.
So that's what the disclosure officer is submitting to you, a schedule plus a copy of the documents that are mentioned in the schedule.
Yes.
Yes? What about material that's not mentioned in the schedule? How did the reviewing lawyer go about ascertaining what steps had been made to collate material to decide whether it should go on the schedule?
Well, you're meant to review the whole case and presumably make a list of what should be there. The matters just mentioned about the drafting of the statement or the amending of it, and as you go through it, presumably you make a list. And I think yesterday you enclosed in one of the documents as to what should be on it, plus depending on the kind of case it is. And presumably here we're requesting a lot of information from Fujitsu, and it's not forthcoming. And if those matters that underline the prosecution case and assist the defence, that's the test. And the fairness of the trial, all that needs to be requested, asked for, searched for, and then subsequently listed before you sign it off or submit it to the defence.
In this case, this wasn't one of those cases where the investigatory work had been carried out by and only by the investigator, and the reviewing lawyer was not cited on any of it. We've seen from the email exchanges that we've looked at so far that you were included in a series of emails which made it clear that you were in possession of relevant material.
Yeah. It's on the file. It should be on the file.
And so why was that material not listed on the schedule?
It is quite notable, isn't it, that any material there that has been listed isn't stuff that involves Jarnail Singh in his capacity and as far as involvement goes in the case in that investigation evidence gathering stage.
I honestly can't say why, but I don't know. When was the actual information sent, the non-sensitive material, the schedule, when was it sent to the defence?
So when was the non-sensitive
This
material?
must have been served on the defence, this being the final.
I don't know. At some point, presumably after the 8th of September 2010.
Yeah, I know certainly this matter was dealt with the other lawyers in the office, and I think around about that September 10, I was away for a long period. I wasn't leaving the country. That's the reason why I can't really...
So what did you do to tell the new lawyer, look, I've been party to dozens of emails in which the third party, Fujitsu, has been asked a series of questions, some of which they've answered, some of which they've declined to answer or feel unable to answer. That material needs to go on an unused schedule. Here it is.
The person who would have dealt with it would have been my supervising officer.
Who was that?
Supervising officer.
Who was that?
Or the the head of criminal law team.
Who was that?
Rob, I think Robert.
So he took over the file whilst you were away, did he?
I think he always kept an eye on it.
No, you're talking about something different here, Mr. Singh.
Yes,
You're telling us that... You're telling us
he took over. He took over for that period I was away.
Okay, when did he take over from?
I think probably, I don't know, I think it's probably about end of August, beginning of October.
So he took over from the end of August until the beginning of October?
Yeah, I think I was away for a long period, about 3 or 4 months. I wasn't even in the country. I had some things to sort out and I got the leave to go.
And so presumably you said, look, Rob, we've got all of this unused material here. I've got it. It's on my file. It's on my email inbox and outbox. Here it is. This needs to be listed on the unused.
This is one of those cases, I think we sat together and reviewed it constantly over a period of time. I think it was sort of more or less up to date because it was one of those cases where I feel a lot comfortable with the fact that it's been looked at, reviewed by the barrister who would deal with the trial.
It seems a bit wishy-washy though when doing very specific things like schedules of unused material. Seems too casual to approach as, oh, I'm kind of going away, but we chatted about it and he kept an eye on it, because clearly there's stuff missing, and clearly this is obviously a risk if there isn't robust processes in place to deal with this kind of thing.
Came to the trial, and subsequently my line manager, so if there was anything I overlooked, he would pick it up, and vice versa. And that's one of the reasons why the disclosure was dealt with the way it did, in the fact that I kept the counsel, the barrister in the case, up to date with everything and all seeking advice as the matter progressed. Because it's one of the...
I'm asking you, Mr. Singh, about what steps you took to ensure in this period of absence that you're telling us about, the material that you were in possession of that undermined the prosecution case was included on a disclosure schedule. What steps did you take?
I think, firstly, the fact that I think he was my line manager, and on top of it, that we were dealing with it, together. And then I think before I left, I think we had the case we had the date for the trial, and I don't know whether we sat together and he made notes, or I actually dictated notes. I don't know how now that exactly how this came about.
Do you accept, Mr. Singh, that it's a serious dereliction of the prosecution's duties?
Yes, of course.
Not to have included on this schedule or any schedule of unused material the email exchanges that we were looking at earlier?
Yes, agreed.
And a serious dereliction of the prosecution's duty not to include on this schedule or any schedule the draft witness statements of Mr. Gareth Jenkins, which were materially different from the signed versions.
Yeah.
And your answer to that is essentially you need to ask Mr. Wilson about them.
Yes. Well,
it's not down to you.
No, I accept that fact. Maybe I should have done more, but certainly for that particular period.
What do you think you might have done more?
More in the sense that maybe I should have had something, more in the sense that, I don't know, make everybody aware of it, maybe I should have listed it, I don't know. But I think I sat with him almost constantly, and also I think he more or less on and off took over the case to have a look. I think he was reviewing it all the time. I don't know whether he made notes on it, but I mean, it's such a long time ago, I can't recall exactly what
Thank you. That can come down.